Happy Halloween! Hi drillers, hope you're having a good night. Hope you're dressed up as something scary. Hope you're eating a lot of candy. I'm not, because I have to keep my very, slim figure, my ripped abs and these guns right here. So I'm not gonna have any candy tonight. Thought instead I would do a review video for you. One that's not scary, one that's inviting and educational. So, with that in mind, let's talk about how a case gets to the Supreme Court. And really there are three different ways, or three kinds of cases that the Supreme Court takes. The least common is something called original jurisdiction, and those are cases that begin in the Supreme Court, and they usually involve a state or an ambassador of some kind. But really the most common routes are either the state route, where if you don't like the decision in a state Supreme Court, you can appeal it to the United States Supreme Court. But the most common of all, of course, is the federal route, in which a case begins in a federal district court. For us here in Bakersfield, California, we would begin in Fresno. And then if you don't like that, you appeal it to a circuit court. We are in the 9th Circuit Court of Appeals. There are 13 circuit courts, 12 depending upon how you count it. Some people say 13. But you have these circuit courts. And if you don't like that, then you can appeal it to the Supreme Court. And so what happens is the Supreme Court has complete discretion, pretty much, except for original jurisdiction, over which cases they take. And they take about 80 to 100 cases a year. But they get about, they get over 100,000 applications, over 10,000 petitions a year, not 100,000, 10,000 petitions to hear the case. So the Supreme Court accepts about 1%, maybe even less than 1% of all those petitions a year. And if you apply to the Supreme Court, what you want is a writ of certiorari. The Latin for that means to make more certain. You want to make sure that the Supreme Court is going to take your case and put its seal of approval on what the circuit said, or maybe disagree with what the circuit court said, especially if it's the 9th Circuit. But at any rate, what you want is a writ of certiorari. You want the court to grant certiorari. Now, you have 9 justices on the Supreme Court. How many of them have to agree in order to hear a case? Not decide it, just hear it. And the answer for that is 4. It is called the rule of 4. You only need 4 out of the 9 justices to agree to take a case, and then certiorari is granted. Now, once they grant certiorari, what they do is they take the case and they place it on the docket. The Supreme Court operates from October to June of every year. You always know you're going to hear headlines about the Supreme Court in late June, because that's when all the blockbuster decisions are always announced, is June 28th, June 29th. And so then, once they've placed it on the docket, then they begin to listen to what the public has to say. I know most people think of the Supreme Court as being completely insulated from public opinion, but in fact, they will take, essentially these ideas of outside groups. They're called amicus curiae, or friends of the court, amicus briefs, that outside groups, corporations, law schools, businesses, interest groups, they can all give their 2 cents to the Supreme Court. You know that the Supreme Court justices aren't doing that. All the law clerks are doing all the heavy lifting, but they're going through those amicus briefs. Finally, the day of oral argument arrives. Typically, each side gets 30 minutes. If a law of the federal government is being argued in front of the Supreme Court, the Solicitor General is the one who argues that. Elena Kagan, who's now in the Supreme Court, used to be a Solicitor General. And so each side typically gets 30 minutes. If it's a big case like Obamacare, they actually give hours and hours to it, but that's very rare. Finally, after everybody has had their say and the 9 justices have questioned the 2 lawyers, usually on Friday they go to the conference and they go around the table and they say where each of the 9 justices stands on the case. And you know who's going to win. You know who the majority opinion is. You know who the minority opinion is. At that point, you have to start the heavy lifting. You have to start writing the opinions. And the Chief Justice, John Roberts, will give those assignments out. It takes 5 votes to get to a majority opinion. And so you have the majority opinion. You have the dissent. If you're in the minority, you have a dissenting opinion. Any of the justices can write what we call a concurring opinion. And there are some principles that sometimes they obey. Once in a while, you'll have a decision where you don't know which justices took what side. It's an unsigned decision. That is called per curiam. And sometimes they will just defer to what previous courts have said. And that would be the legal principle of stare decisis, which means let the decision stand. So I hope this is helpful, and we'll see you on Monday.